Here begins DVD number 1 in the Volume 3 testimony of Ramesh Sunny Balwani in the matter of Theranos, Inc. in the U.S. Securities and Exchange Commission file number SF-04030-A. Today's date is September 7th, 2017. Time on the video monitor is 12:28. Video operator today, employed by BEMKE Reporting and Video Services, Inc., 160 Spear Street, Suite 300, San Francisco, California.
Great, and we are on the record at 12:30 p.m. on September 7th, 2017. I'm Rahul Kolhatkar. With me are Michael Foley, Mark Katz, and Monique Winkler. Joining us in a minute will be Jessica Chan. We're all officers of the Commission for the purpose of this proceeding. We are today resuming the examination of Sunny Balwani, which was adjourned on August 10th, 2017. Would counsel please identify themselves?
Yes, Jeff Coopersmith from Davis Wright Tremaine, representing Mr. Balwani.
John McKay, also Davis Wright Tremaine, representing Mr. Balwani.
Jim Topinka, same firm.
Testimony today is pursuant to a commission subpoena, which I've marked as Exhibit 268. Mr. Balwani, have you had a chance to review Exhibit 268?
Yes.
Do you understand that you're appearing here today pursuant to Exhibit 268?
Yes.
Mr. Balwani, do you understand that you remain under oath?
I do.
I'd also like the record to reflect that a copy of the formal order of investigation of this matter, as well as the supplemental formal order, are available to counsel and the witness during the course of this examination. Since we adjourned on August 10th, other than your conversations with counsel, have you had any conversations with anyone about the substance of your testimony before the SEC?
No.
So, Mr. Balwani, when we met last time, we discussed Theranos' relationship with Walgreens and the innovation fee. Do you recall that generally?
Yes.
I wanted to just ask you a couple more questions about that to help clarify your understanding of the innovation fee as of 2014.
Okay.
So I'll hand you what's previously been marked as Exhibit 49.
Thank you.
Do you recognize Exhibit 49?
I do.
What is it?
This is the Master Services Agreement executed between Theranos and Walgreens, actually amended and restated in 2012, June 2012.
So it was amending an earlier agreement that Theranos had previously had with Walgreens?
Correct. We had an original agreement I think we had signed in 2010, sometimes during the summer, and this was amendment to that.
Did you review Exhibit 49 at or around the time Theranos entered into this amendment?
Yes, I did.
And last time I think we talked about Theranos's right to retain the innovation fee.
Correct.
And I understand your general testimony to be that, subject to a couple of exceptions, the $100 million innovation fee paid by Walgreens was non-refundable.
And just for the record, the transcript's going to speak for itself. You know, if you're trying to get him to repeat what he said earlier, he may not be able to remember exactly what the question was or what he said.
Sure, I guess. What was it your general understanding after Theranos entered into Exhibit 49 that any innovation payments made to Theranos were non-refundable?
It was not necessarily the 2012. It was also the amendment that we signed end of 2013. Taking those together was not refundable. This part of the innovation piece, even this contract calls out was not refundable, but I will have to look at the exact language of those two.
Okay, so my question to you is, what part of, I guess, Exhibit 49 helped you develop the opinion that that part of the innovation fee was non-refundable?
Well, there are two things. First of all, I negotiated this contract with Walgreens. I was the lead point from Theranos. And the intentions of both parties was that it's not refundable. So that's how we entered in these discussions, that the $100 million was non-refundable, and we will structure it such a way that Theranos receives the payment over time, having achieved certain milestones, but the language in this contract and the amendment put together made it, it captured that intent.
I guess, can you explain that distinction between Theranos might receive the payment and earn it over time?
Sure. This contract in 2012 split the payment, I believe, in 2 or 3 payments. I forgot exactly what was in this contract in 2012. And there were certain milestones we had to hit. I think success of the pilot was one of those, and some other details around the innovation payment that triggered additional payments. So initially, I think the first payment was going to be for $25 million, if I recall, and then there were additional trigger points that will allow us to receive the payment, because if you haven't received it, obviously there's nothing, you haven't earned it. And then the language in the contract was that once we had received the payments, it discussed what the payments was for, and based on those discussions in the contract and also what was in the amendment signed on December 31st, 2013, we structured those 2 documents such that we get to keep the payment, and the payment became non-refundable to Walgreens.
Can we turn to Section 6 of this contract? It begins on the page ending Bates WAG TH 55 and on to 56.
Yes.
And you see the section that's entitled Section 6 Innovation Fee?
Yes.
And I think the sections you reference that you just referenced in terms of the schedule of payment being laid out on certain milestones, is that captured by 6A here?
Seems like it, yes. I mean, I'll have to read the whole thing, but from just looking at quickly, it seems like it, yes.
Well, why don't you take a minute and review Section 6 just yourself and let me know when you've had a chance to read it.
Do you want me to read the whole page or just the first top section?
Why don't you read the whole section onto the which continues onto the next page?
Okay.
You've had the opportunity to review Section 6?
Yes.
And so I guess my question initially was, does 6A capture sort of the earning events that you described in your earlier answer?
Seems like it, yes.
And is it fair to say that...
Well, I think that question may have misstated. It doesn't really say earning events. It's distribution events. Right?
Sure, I appreciate that correction. So does Section 6A capture the distribution events
It does.
in the contract? And is that essentially that there was $25 million paid up front?
It was not up front. It was at the completion of due diligence items, as it says over here.
And did those due diligence items take place?
Yes.
Did the Section 6B 5, the facilities visit section, describes describes the potential for a facilities visit. Do you see that?
I do.
Did that visit take place?
I don't recall if that particularly took place or not. I don't.
Was it your understanding that it took place at the satisfaction of Walgreens such that they made the initial $25 million payment?
It was my understanding that if there was anything outstanding that they wanted out of this section, they would have brought it to us. But the fact that they triggered this $25 million payment to us meant they were satisfied.
The Section 6A2 refers to a second $25 million distribution. Do you see that?
I do.
Was that to take place upon Theranos reaching 10 patients per store during a pilot?
That's what it says here, yes.
And then again, the subsection 3 there has the sort of the last distribution clause. Do you see that?
I do.
And were those was the timing of the second and third distribution sort of what was renegotiated in that 2013 contract?
I don't think it was just the timing. I think there were other key provisions of the contract that were also renegotiated in the amendment that we signed on December 13th, or 2013. Sorry, December 31st, 2013. It was not just the timing of those two payments.
Understanding that's not just the timing of those two payments that was renegotiated as part of the 2013 amendment.
Right.
Was the timing of these two events renegotiated as part of?
I mean, I don't think I would describe it as renegotiating the timing. It was basically we had renegotiated key terms of the contract. As part of that, Walgreens accelerated those $75 million, not tied to these milestones anymore. So they were not tied to these milestones at all. It was basically completely new language and new understanding that the companies arrived at.
If you look at section 6C, it states, if Theranos realizes at least $1.75 billion in net revenue domestically from laboratory services it provides at all of its laboratory locations that utilize the Theranos system within 12 months of the date that Theranos tests are available in at least 1,000 locations, Theranos will earn $50 million of the innovation fee. Do you see that?
Yes.
What did that provision mean to you at the time Theranos entered into Exhibit 49?
So there was a lot of background to why we structured this contract the way we did, and especially this whole payment section here. If you look at the language towards the top that you had earlier read, or actually we pointed out, was that the innovation payment granted in this agreement is in exchange for exclusivity, price protection, first announcements rights, infrastructure costs, and so on and so forth. So there was a lot of value that we were going to give to Walgreens in exchange for innovation payment. Now, the question was, how does the innovation payment show up on the contract? For reasons that were clear to Walgreens, and I didn't quite fully understand why, they wanted to structure the contract in such a way that it reads this way, which is basically that even though if you read the contracts in entirety, and especially after the amendment, but you're saying ignore the amendment for now, correct? Yeah, so at this point, the way this contract read, we had two milestones that we had to reach in order for us to earn, and if not, then there was this clause that says it's going to get triggered, and I think I mentioned that there were some exceptions to that innovation payment, that this clause will trigger that will say that we will trickle back dollar for dollar some amount back to Walgreens. Now, if this is all you read, then you will miss the other point here, which is that this contract also talks about what happens during the if the contract terms. And the way this was structured this way was on purpose, that if that section ever got triggered, which is that if we, for some reason, got to 1,000 stores, first of all, our understanding was if you get to 1,000 stores, things are going extremely well. And Walgreens is making a lot of money in 500 stores, 600 stores, 700 stores before we hit 1,000 stores. But once we get to 1,000 stores, and for whatever reason, we are not making the revenue numbers that are targeted over here, then things have not gone well. Theranos had the right at that point to term the contract or not renew the contract. And if we don't renew the contract, this payment is non-refundable, and that's under those circumstances. So that was kind of the way we structured, is that the contract was that way.
So just so I understand your answer to the question, I think the question was, does that sentence in the first sentence of section 6C refer to the first event Theranos would have to, the first event that Theranos would have to achieve before it earned $50 million of the innovation fee?
Yeah, and my answer to that is you cannot read one sentence from this thing and miss out a lot of the other details that went into the contract that basically gave me the reasons that this money was non-refundable. It's not possible to read just one line and ignore a lot of the other things that went into the contract and why the contract was structured this way.
So why don't we turn the page to the page ending WAG TH 57.
Yes.
And the second to last sentence of Section 6C states, if the aforementioned milestones are not realized, Theranos will refund the entire innovation fee, dollar for dollar, back to Walgreens on a per test consumed basis, with at least $50 million being credited in the first 12 months after program launch. Do you see that?
I do.
And is that the section that you were referencing that related to sort of the trickle back of the fee?
Yes.
And is what I understand your testimony to be today that sentence wasn't an avenue to refund the innovation fee?
And that one sentence, if you read it without the benefit of everything else in the contract, implies that if we have not succeeded, first of all, this gets triggered only if we are in 1,000 stores and we have not reached $2.5 billion. If that happens, that means things didn't go very well the way we planned. So there are things that will trigger it. The discussion we were having with Walgreens was, why would we hit 1,000 stores if things were not going well, right? I mean, if you are in 500 stores, things are going well, only then you would go to 600 stores or 800 stores or 1,000 stores. So the point here was, by this time, we are in 1,000 stores. For some reason, things for Theranos have not gone well, even though we are in 1,000 stores. And we actually did math around what would be the revenue if we are in 1,000 stores. So the expectation was we will easily surpass those revenue numbers. But assuming that was not the case, the language here basically said, if that happens, you trickle back. However, in that case, Theranos had the right to not renew the contract. And if you look at the contract language, when the contract is not renewed and it expires, this money becomes non-refundable to Walgreens.
So just so I understand, it's your view that Section 6C, the refund events only take place if Theranos was at 1,000 stores to begin with?
That's what our expectation was. That's what our understanding was, yes.
And just sitting here today, is that how you read Section 6C?
Yeah, that's how I read it.
So you mentioned the termination provisions of the contract. Is that what appears on the page ending WAG TH 66?
Well, I will have to read it, but this contract was pretty complex, so I don't think it was a clear section. I remember where it was, but if it is here, then it'll be here.
Well,
do you want me to read the whole thing?
Why don't you read section 24, which begins on WAG TH 66 and continues on to WAG TH 67.
Sure.
And let me know when you've had a chance to review it.
Okay.
Is this the section? Is section 24 the section you're referring to that relates to the termination of the contract?
I think so, but there may be more in the contract that refers to it, but from reading it seems like this is a section.
Okay, and can you explain to me which part of Section 24 relates to the innovation fee being non-refundable?
Well, it's, if you look at the survival of provisions, the innovation.
Sorry, sorry, just for the record, you're pointing at
Sorry.
24F?
D, 24F, that's right.
Okay, sorry, I interrupted you.
No problems.
There's no E apparently.
I see that.
Yeah. So F here is the one where it says the innovation payment doesn't survive, and that's by design.
Where do you see the innovation?
No, it's not there. If it lists everything that survives in terms of term, and the innovation payment that was delivered back to it was given to Theranos is not, it doesn't survive. It's not refundable for that reason.
Because it's not listed in the survival of
Correct.
provisions?
Exactly right.
If you look at the section before, Section 24D,
Right.
it says obligations upon termination.
Right.
It says the little I and then 1. It says, in the event Walgreens terminates this agreement pursuant to sections 24.b or 24.c, or Theranos terminates this agreement pursuant to 23.b,
Right.
then within 180 calendar days of the termination date, Theranos will refund the innovation fee as detailed in subsections B and as applicable C. Do you see that?
I do.
Does that not contemplate returning the innovation fee in the event of termination?
I mean, not the way I read it. And again, I was sitting there negotiating the contract, and that was not the intent of this provision to capture that. Because if, again, I'll have to go through and timeline the whole thing, but if Walgreens terminates the contract and they have given us the innovation payment, then why would we refund it? Given all of the valuable goods and services that we already provided to them.
Did you communicate your understanding to anyone at Walgreens?
Every single person from Walgreens, this is their language. They created this complicated structure around this contract. We would have preferred a simple language. As if you look in 2015, we actually wanted to simplify that language. But Walgreens did this so that they had Medicare lawyers looking at this thing. They wanted to make sure that this $100 million was not seen as a kickback or anti-kickback laws. So they structured it in such a way that it satisfies their requirement, which apparently it did, and it satisfied our requirement and our understanding that $100 million, once we hit the milestones, is non-refundable to Walgreens. And there were not just one or two people, an army of Walgreens lawyers and executives who worked with me and negotiated this thing. The other thing, if I may add to this one, is in 2015, late 2014, I had a conversation with, and they confirmed it. They said, you know, there's a contract is ironclad, that money is not refundable, you know, but we would like to renegotiate to see if we can provide you some other services and goods, and discuss, you know, when we were negotiating the landlord-leasing model in 2015, to discuss that.
So in that last answer, I think you mentioned that once you hit the milestones, it's non-refundable. Was hitting 1,000 stores not one of the milestones for the innovation fee?
No, this is in 2012. Once we modified the contract in December 2013, that obviously changed the terms of the contracts very significantly. So, which is why I'm talking about both of them combined together for the 2014 timeframe.
Who is your lead point of contact in the 2012 amendment for negotiating Exhibit 49?
There were a large number of people who came and went at Walgreens. Then there were a large number of business executives who were involved. I think, and I'm going to forget names because they used to have so many people come and go at Walgreens. After that, I believe we had, there's another guy who came, I forgot his name.
Do you recall any, I'm sorry if I interrupted,
No,
anyone else that you recall?
Well, there were many more. I'm just trying to think people off my head. Yeah.
Those are the most prominent people in your mind? So with respect specifically to the 2012 amendment, Exhibit 49, do you remember who from Walgreens suggested the language, as you described it, in Section 6 and 24?
Well, I wouldn't know who from Walgreens suggested it because when the contracts came to me, it came from either in 2012 or from, that's right, But he would tell me that he got feedback from dozens of people at Walgreens. I mean, so it's a pretty sophisticated company they had a lot of people looking at these contracts. Every single line they would come renegotiate it because some other executive had jumped in at the last minute. So, but he was a point person.
Yeah,
so where the language came from, I don't know.
But in terms of who communicated to you, it would be okay.
Most likely, yeah. And it could have too. He was also involved, but the one who was working with me on the language of the contract.
Well, what about on the Theranos side, other than yourself, who was involved in focused specifically on the language of the contract?
Well, I used to run everything by Elizabeth back then because we were a small company in 2012, 50, 60, 70 people, something like that. So I used to always, tell her what was going on in the contract. I would show her the language, but then I would be editing it. And then I believe we also ran it by our outside counsel, who looked at the contract language to give us advice on different issues, different matters.
And without inquiring about the nature of the advice, who was outside counsel for?
I believe it was the outside counsel.
Any particular partner or a lawyer there?
I wouldn't remember the names. It's been 7 years, 6 years, 5 years.
Okay, you can put Exhibit 49 to the side.
All right. Oh, sure.
I'm going to hand you what's been previously marked as Exhibit 265. Thanks. So I think in one of your answers a minute ago, you referenced the 2015 negotiations. So I've handed you what's been marked as Exhibit 265. It's bait stamped THER-0982058. I'm not going to ask you to review it in full, but if you could review the cover email at least and let me know when you've had a chance to read it.
Okay.
Do you recognize Exhibit 265?
I do.
What is it?
In 2015, we had started to renegotiate our agreement with Walgreens, and it seems like this is one of the drafts of that process.
And is it an email for, that you sent to Ms. Holmes forwarding a message from?
Yes.
And did they attach a proposed draft of that contract?
Seems like it, yes.
And if you look at the the second paragraph of the email from yourself to Ms. Holmes, did you write the innovation payment language is closer to what we had wanted?
Seems like it, yes.
Okay. So I want to turn to the innovation language. It looks like there are basically two copies of the contract attached. One's a red line and one's a clean copy. If we could look at the clean copy at the page, Bates ending THER 0982063.
Sorry, 63. Okay.
It looks like the innovation fee is now Section 5 of the contract, and it goes on the next page. Do you see that?
I see it.
Could you read subsections A and B and let me know when you've had a chance just to review them to yourself?
Okay.
Do you recall reviewing this draft contract at the time?
I probably did, yes. I don't recall it, but I'm pretty sure I did.
Can you tell me what about this proposed language for the innovation fee is closer to what you'd wanted in 2015?
I wouldn't be able to recall that, what I had said to her, what we had in my mind, or what we had discussed. But I mean, I can respond to what's here, but I don't recall.
I guess what was do you recall what you had in mind in terms of what you'd hope to see in terms of language for the innovation fee?
No, I mean the negotiating process with Walgreens was a pulling hair process, and you will go back and forth with them, negotiate 1,000 things, and then land on something. So I wouldn't recall every single detail about what I expected in a certain draft. I'll have to look at all the communication and my notes to be able to do that.
Generally, do you have a recollection of what your hope was in terms of the innovation fee in that contract negotiation?
Yeah, I mean, I think first of all, it's important to draw a line between the use of word innovation fee. The way we had used the word innovation fee in the original contracts through December 2013, when we signed the amendment, and what we were negotiating here. This is something that we hadn't signed, as you know. This is 2015 negotiating drafts. So internally, we were using this innovation fee as a label towards the money that we had earned to see how now we can incent Walgreens to do things that were favorable to us in a certain way. So we were going to use this money now to create some incentives to, for Walgreens to be able to give us some terms. So for example, we were negotiating the economic terms of the deal. The original deal, we were paying them $10 per transaction, and the new one, I wanted to pay them actually $0. But we were still negotiating. We were going back and forth between 4 and 6. Ultimately, my intent was to bring it down to 0.
Why did you use the term innovation fee to refer to that latter point?
It's just a label we used towards the money that we had earned, and now we were going to use it for our business in however we wanted. And because, at least in my mind, we had earned it from Walgreens, I was going to use it now to see if we can, use that money to build out stores at Walgreens, or incent them to give us something that we wanted, incent them to give us some terms that otherwise they may not have agreed to. So it's like referring to money as kids' college fee, but then using it to buy a car. I would do it, but it's a label that we were using internally. It's not like a jersey that we had retired forever in January of 2014 that we will never use this term again. It was more loosely referring to the money that we earned from Walgreens and how we can use it now as we were sitting on the table and negotiating the contract.
If you take a look at the proposed subsection B there, 5B on THER-0982064.
Yes.
It still includes language about opening 1,000 locations and certain amounts of net revenue. Do you see that?
I do.
In your view, is this language no longer applicable in 2015?
No, in my view, we were negotiating. And in 2015, like I said, Walgreens, it's a contract negotiating organization. These guys negotiate contracts with the most aggressive companies in the world: pharma companies, insurance companies, hospitals, tobacco companies, alcohol companies, sugar providers. I mean, these guys know how to negotiate contract. And I learned a lot from these guys. So at this point, I was keeping things in play so that I can get things from them and show them carrots so I can say, there's something in for you. But this is a negotiating process. Doesn't mean I had agreed on this language or any language. As a matter of fact, this is a draft they sent me in February of 2015. Even through September of 2015, we still hadn't agreed on a contract. We were still going back and forth. So, like I said earlier, my intent was that if we were going to incent them by saying, okay, here's some money we can give to you, which I understood needed badly, then here are some concessions I would need from you. And like I said, the per patient fee that I brought down from $10 to $4, I was going to get it down to $0.
Did you view Walgreens' proposed contract language here as a suggestion that they didn't believe the innovation fee was completely earned by Theranos?
No, that would be false. They knew we had earned it. That was what we negotiated. And like I said, it was not one young MBA from Walgreens who negotiated this contract. They had an army of people who negotiated the contract. Walgreens has the habit of coming back and asking you for your first child if they could have it. So just because Walgreens said that they wanted this money back and that thing back doesn't mean it's theirs.
Who at Walgreens I think you mentioned this in a prior answer as well. Who at Walgreens told you that Theranos had earned the $100 million innovation fee?
I think I answered the question earlier. Every single person at Walgreens back then when I spoke with, even in 2015 when they visited us, they said, you know, we have looked at this contract, it's ironclad. You have earned it. It's not refundable to Walgreens.
Do you recall when in 2015?
Summer of 2015 when I was negotiating this contract with them.
Did you have any communications with them prior to 2015 about this point?
Yeah, I mean, all along since 2012 when we signed the amendment, in 2013, 2014, this thing about this is refundable to them, and if XYZ happens and they could just ask for a refund, was not on the play. This is what we had negotiated. If you read the language, what they wanted from us was not to go to CVS. They wanted us to stay away from CVS and others. They also pushed for Walmart and Target and others. And if you read the language around the original exclusivity, they didn't say we are giving them exclusivity around finger sticks or around software or around this and that. It was exclusivity that was the prime key value to them. So every single person on the other side at Walgreens knew this is what we were negotiating for.
So the language that's under, I guess this is 5B in Exhibit 265, it seems identical to the language that's in 6C on Exhibit 49. If Walgreens thought that the innovation fee was not refundable, why, and that was your understanding as well, why would this language have been kept
Because
from the last amendment?
sorry, I didn't mean to interrupt. Because they are Walgreens, they would ask you for everything they've given you back and some if they could. This is how they negotiated. They are retailers, cutthroat business, 4% margins. This is how they negotiate. So this draft came from Walgreens to us. This is not me saying, yeah, good idea, just put this language in there. If it were up to them, they would have, if you look at the red line, they would probably have removed a whole bunch of things that were favorable to Theranos from this contract and kept stuff that's favorable to them. So this was their habit. And this is why a contract with Walgreens took, you know, months. And anytime I had to go and negotiate a contract with Walgreens, I mean, I used to pray that I can get out from the meeting safe, because these meetings took a long time, and these guys knew, and their thing was they would put everything in the contract. We will negotiate with one guy. Let's say I will sit down with, we'll negotiate something. We will agree, we redline it, we'll remove it, goes back to Walgreens, they'll sit on it for a month and come back and the same language is there again. And they say, oh, this other executive thought this was important to us, so let's renegotiate. That's why it took so long. And that's why they will put it back anytime. Even if I removed it 10 times, they will put it back. Doesn't mean we agreed to that.
Did Walgreens auditors at Deloitte ever contact Theranos to analyze the collectability of the innovation payment?
I don't recall if they contacted us directly. I think there was 1 or 2 conversations we had early on, maybe in 2011 or 12 around that issue, but I don't remember the exact specifics. If I see some documents, I'm sure it'll refresh my memory.
Do you recall any, just from your memory, if you provided them with any information?
You know, I don't think we provided them anything, but I could be wrong about that. I will have to kind of look at my communications with them.
Were you aware in 2014 that Theranos had retained KPMG to conduct a review of its 2012 and 2013 financial statements?
I don't know exactly whether it was we retained them in 2014 to conduct 12 and 13 statements, but I do believe we had retained them to audit our financials for 2012, 13, and beyond. But I don't know if that happened in 2014, and if those are the only 2 purposes.
But you did understand KPMG was auditing Theranos' financials, is that?
We wanted them to audit our financials, yes.
Whether or not they completed or not, they were engaged to start that work.
They were engaged to start. I don't know if they even started their work.
Were you aware that KPMG believed that the initial innovation fee payment should be accounted for as a customer deposit on Theranos' balance sheets and should not be recognized as revenue?
I don't think KPMG got deep enough into any of those details to be able to form that opinion. And so the answer is, if this was their opinion, I would have known about it, but I don't think this was their formal opinion.
In other words, you were not aware of that opinion from KPMG?
That's correct.
With respect to Deloitte, why would they be asking for evidence of collectability of the innovation fee if the innovation fee wasn't supposed to be collectible by Walgreens?
Do you have a time frame as to when you're saying Deloitte was asking the question?
Well, Mr. Balwani, you recall that there were discussions sometime in 2011 or 2012. That was what you said in your testimony.
No. What I was responding to the questions, if I recall a Walgreens auditor asking us for something, and my response was, I didn't know it was Deloitte or who the auditor was. My recollection is, I think we had a discussion with Walgreens around that, but I don't remember the specifics of what it was. And I certainly don't know why Walgreens auditors would be asking for something from Walgreens. I would not be able to comment on that.
So what were the discussions that you recall happening in 2011 and 2012?
I don't. I just remember that we had a discussion around this topic, but like I said, if I saw my email communication with the Walgreens guys or whoever, chances are it's going to be with lawyers or accountants there. If I saw those, it'll probably refresh my memory. I can comment on that, but it was so long ago, there's no way I remember that.
When, in your prior testimony, we generally discussed Theranos' financial model and the potential to perform services for pharmaceutical companies at Walgreens locations.
Yes.
Did Theranos have a team of employees working on potential pharmaceutical services in 2014?
No, I think I had commented that we had to hire somebody to lead that effort. At that point, we hadn't. I mean, before I came to Theranos, this is what Theranos did, and there were people who were familiar with this business who had engaged with pharmaceutical companies before I had come on board. So in a way, yes, we had those people, but in order to fully engage with that business, we had to build the team from again.
In 2014, was it anyone's job at Theranos to work on pharmaceutical services?
Not to the best of my knowledge.
What document would best reflect your expectations for Theranos' retail growth at any given point in time?
I'm not sure I understand the question.
So we talked when you were here last time about the financial model.
Right.
Do you recall that? Would the financial model best reflect your assumptions about Theranos' likely retail growth at any given point in time?
I'm not sure if I'm answering your question, but I'll attempt it. The financial model I was using as a planning tool also. So all the information that came to me from field and from the internet, whatever I learned, I think I mentioned that to you also, I would put that in the model. So in a way, the answer to that question is yes, the model did reflect my assumptions about growth, because like I said, I was using this as a planning tool for business also.
Were there any other documents other than the model that you would have used to sort of plan out your expectations for retail growth at Walgreens or other retail locations?
I mean, I think the answer to that is no, but I actually also don't know what would be, for example, if there's an email exchange between me and Walgreens or some documents or meeting minutes from them that came, and I was aware that document is there, would that be considered a document for that purpose or not? But I'm trying to narrowly define content that I personally proactively created, and model I think would be the one.
I also want to clarify a couple points on your understanding of Theranos' CLIA lab operations.
Okay.
Who at Theranos made the determination of what device to use for patient testing in the CLIA lab?
It evolved over time. Initially in 2010, 2011, it was, I think, I was not involved. It was the lab. We had one lab director with 3 or 4 individuals. They did some research on what to pick, what to use, and they had picked the original devices. And then after 2011, from a product dev perspective, I got involved to understand how the other companies use it. And then I started playing more and more active role. But even there, my participation was from a business perspective. The technical decisions were being made by the CLIA lab directors and the scientists and engineers in the company.
just using a hypothetical of a test that can be run on just any of the three models, either the TSPU, the modified, or the unmodified, who would have the final say about which machine Theranos should use to test CLIA samples in the lab?
Well, the final say is always the lab director. So lab director is, if they don't sign up, that's the end of it.
Okay.
But
was that true throughout your time at Theranos?
yes.
Was it your understanding in 2014 that Theranos primarily used third-party analyzers in its CLIA lab, whether modified or unmodified, for patient testing?
That's a difficult question to answer. Are you talking about in terms of number of devices or number of tests, or primarily in terms of what?
In terms of number of tests.
I wouldn't be able to answer. I would have to look at the data, but I mean, the modified devices were not commercially available, as you know. I think I explained to you they were very significantly modified. So I considered them as not commercially available devices anymore once we modified them to the extent that we did. So I would say if you use Theranos' technology, then I would say in 2014, majority were being used on some form of Theranos' technology. But again, I could be off. I'll have to look at the data in our lab information system.
What do you mean by Theranos technology in that answer?
Well, when we modified the commercial analyzers, we modified the software, the hardware, and a bunch of other things that I think I had shared that with you. So that made them not commercially available anymore, significantly modified. And that I consider that as Theranos proprietary technology. We had a discussion about that around our trade secrets. So if you take that world, then I would say majority of the testing was being done on those devices, on Theranos' technology. But I could, like I said, I could be wrong. The numbers changed by month, based on ordering patterns and a bunch of other things.
In that last answer, would the Theranos technology also include the TSPU?
Yes.
Okay, so is it fair to say that in your view, Theranos' technology consisted of, in the CLIA lab setting, of the TSPU and then the modified third-party devices?
Yes.
Is it fair to say that the unmodified third-party devices would not be Theranos proprietary technology?
If you're talking about only in the context of the CLIA lab, the answer is yes.
I'll hand you you can put the other exhibits aside, thank you. I'll hand you what's previously been marked as Exhibit 201. And I'm not going to ask you to review this in full, but if you could review the cover page and let me know when you've had a chance to understand what this document is.
Okay.
Do you recognize Exhibit 201?
I can recognize by looking at the cover page, yes.
Do you understand it to be Theranos' responses to a set of interrogatories in the PFM litigation?
Seems like it.
If you turn to the page ending in 3358, do you see request number 64 there?
I do.
And you see that it's asking Theranos to identify any commercially available machine that Theranos modified for use to process tests on capillary or other microsamples.
I do.
If you look past the, if you turn the page to 3362.
Okay.
Do you see that part of the answer lists 4 devices there? The Siemens Advia 1800, BD Biosciences, LSR Fortessa, BD Biosciences, FACSC, or FACSCS
Fax
Canto
yes.
2, and the Drew Scientific Drew 3.
I do.
Is that consistent with your understanding of the third-party machines that Theranos modified in order to test capillary or microsamples of patient blood?
In the CLIA lab.
In the CLIA lab.
I think that seems right.
Was this also your understanding at the time these devices were modified for that purpose?
For what purpose? For CLIA lab patient sample testing.
In other words, there's some time periods here listed for when these devices were used.
Yeah, I mean, I don't know about the time periods, obviously, but the device names sound correct.
Was it your understanding from 2013 to 2015 that these 4 third-party machines were being modified by Theranos to test patient samples?
Correct.
Were you aware of any other third-party machines that have been modified by Theranos to test patient samples in the CLIA lab?
Off the top of my head, I don't know. I can't think of any.
Who at Theranos would best know the answer to that question?
Well, the lab director, but would know. But I think this information is in the software. Software tracks all single details, so no one person has to really memorize this information.
Would that software also reflect the machine in the LIS database as sort of the output?
Yes.
If you turn to the next page, in response to D, there's a list of tests that were available to be run on the modified ADVIA 1800. Do you see that?
I do.
Can you take a minute and just read the list to yourself, please?
Sure. Okay.
You've had a chance to review pages 3363 through 3366?
Yes.
You see that it lists 49 tests there?
Yes.
Is this list that appears on those pages consistent with your understanding of the tests that were run on a modified protocol of the ADVIA 1800?
I wouldn't remember exact tests running from what time to what time, so there's no way for me to be able to memorize this.
You don't have any personal memory on a test-by-test basis?
Unfortunately, no. That would be nice, but I don't.
What about for the, if you look at the paragraph below the last, below number 49, it references the fact that the BD Biosciences LSR, Fortessa, the FACS Canto 2, and the Drew Scientific were used to process complete blood count test panel.
I see that.
Was that consistent with your understanding of what those 3 machines were used for? In the CLIA lab again?
I think so, but I could be wrong. These are pretty arcane lab details, but I would say from a business perspective, it looks reasonable.
Did you remember any other tests being run on those machines?
I think there was one test that we had validated called TBNK. I don't know if it went live or not. It may actually have gone live, but I may be wrong about that. So it may be something that was done in R&D.
So if you look back at 3363 to 3366, which lists the tests that were being run on the Siemens ADVIA 1800 analyzers that had been modified by Theranos, was it consistent with your understanding from 2013 to 2015 that there was a maximum of 49 tests that were performed using the modified Siemens ADVIA 1800 analyzer?
I wouldn't remember the exact number.
Was that around about 50 tests? Was that around, does that seem about right to you based on your understanding?
Yeah, I think my recollection is that in total we had about 80 tests, 70 to 80 tests offered from Fingerstick. So if 40 to 50 are running on ADVIA 1800, that sounds like a reasonable number.
Okay, and that was your understanding back in 2013 and 2015 as well?
I actually don't know if I knew in 2013, 14, 15 exactly how many tests were running on what machine. But at some point over time, I did acquire that understanding that our total number was about that ballpark.
You mentioned a total of around 80, and I think we talked about a dozen being run on the TSPU. Is that
Sounds right, in CLIA lab.
in the CLIA lab? Did you have an understanding in 2014 that about 12 tests were being run on the TSPU in the CLIA lab?
Again, I wouldn't be able to pinpoint dates and times, but the number sounds reasonable.
We've been going almost an hour. Why don't we take a quick break off the record at 1:26 p.m.?
Should I put this away, or do you want to come back to this?
You can put this.